I'm here with attorney Austin Graff. We're at the federal appellate court in Lower Manhattan, and we just came out of a hearing where you gave oral arguments in the Garland case, the Garland appeal against the New York City Fire Department and et al.
Right.
I thought this was a remarkable hearing. For people who are unfamiliar with this case, can you just explain the basics? Who brought this case? What is it about?
So the Garland case is a group of 90 plus firefighters, EMS, and fire officers who refused to take the COVID vaccine. All were placed on leave without pay, suspended without pay is what I call it, without due process is my argument. Some were terminated, some ultimately went back to work, but in this case is to get them justice for the violation of their due process rights for their for them deciding not to take the COVID vaccine and losing their pay for a period of time.
So what are the federal arguments that you're making on the due process claim?
Our argument in this case is that the due process, which was the reasonable accommodation for both medical and religious exemptions, was a sham. That there was no likelihood that that any of the employees would have received an accommodation. It was set up so that the people would apply, but would not get granted the accommodations, and that's a sham. We have to actually have an opportunity to be heard, a real opportunity to be heard, which my argument in this case was that there was no opportunity to be heard. You were able to submit a request, but that request was going to be denied. I made the argument based upon a deposition that 96% of the people who applied to the appeal panel got denied. The city argued, well, that means the lower process worked. I argued that there shouldn't have been 3,200 people who applied. The court seemed very favorable to my argument. Don't know what's going to happen, never know what a judge is going to do, but they seem to be accepting and willing to listen to us. They made some good points that sounded favorable to me, so we'll wait for a decision hopefully soon.
One of the things that I thought was remarkable during this hearing is that the judges discussed those arguments. They also asked you about the ability of city employees, of fire department employees, to challenge the legitimacy of the mandate itself as a condition of employment. Can you talk about that exchange
Sure.
that you had with the judges?
So one of the arguments that we made is that the city imposed this that COVID vaccine mandate without going through the UFA and the UFOA and negotiating with them. And I made the argument that before the city can make it a condition of employment, the vaccine, the city had to negotiate with the union. Some of the people who had disagreements with the vaccine didn't want to take it, and the court said that those people should have had an opportunity, or made the argument in the arguments, that they should have had an opportunity to raise the issue of the fact that the union did not negotiate, or that the condition of employment was not legal. That should have been part of the due process that firefighters should have had an opportunity to be heard. And the city acknowledged that they did not. And the city kept saying that the opportunity to be heard for those people who didn't have either a religious or a medical exemption request was to show a vaccine card or not showing a vaccine card. And the court seemed to suggest that that was not proper due process. So we'll see what happens.
Mm-hmm. So there were three unions involved.
Right, there's a UFA, UFOA, and DC 37. DC 37 came to a union agreement with the city on a citywide basis, and we argued that there was a conspiracy between the DC 37 and the city to deprive the firefighters and the FDNY employees within the DC 37 their due process.
And what is the obligation of unions to negotiate on behalf of their employees to create a condition of employment? What is the legal obligation?
They have to act within the best interest of the whole group, not just some. But in this situation, DC 37, we believe, violated that obligation by coming to an agreement and actually putting into paper an agreement that robbed the members of pay without due process.
It was in the broker case, which we were here for your appeal in the broker case, which involved teachers instead of firefighters, not too long ago, and in that case, the judges were heavily suggesting that this should be a state matter.
Yes, and broker actually turned out that they granted leave to file claims in state court. In this case, while the judges addressed that, it seemed like they still focused on the federal claims more than a state law issue. And I was trying to focus them on the fact that it's a due process and it was a sham. And I think they got it. I think they understood it. In the broker case, not to play politics, but there were two Biden appointees and a Nixon appointee on the panel. Here there were two Trump appointees and a Biden appointee. So it was a different political shift of judges between the two cases.
So what do you see happening next in the Garland?
In this,
the broker decision came down very quickly.
The broker case came down 6 days, which for me was a record. I've had it 3 weeks, months, but I don't know how long this is going to take. My guess is it will be soon, but you never know. The next step is to see what the judges rule, and based upon that, either it goes to the U.S. Supreme Court, maybe state court, I don't know, but we're hoping that we can get back to the district court and this court reverses and remands this case to the district court so we can proceed with discovery and see if we can get the firefighters and the other members of the FDNY some justice in this case.